Hi, my name is Joseph Marion III, and I am a shareholder with the firm of Adler, Pollock Sheehan with offices in Boston, Providence, and Newport, Rhode Island. And I chair the estate planning department for the firm, and I've been practicing almost 25 years. And I'm here today to talk to you about estate planning for those of you who may have recently been diagnosed or are battling a recent illness. And in Rhode Island and Massachusetts, the main building block of an estate plan for most folks are the urgent need for a power of attorney. And a power of attorney is a document whereby you direct another person to handle your financial affairs, called a durable power of attorney for financial purposes. And so the typical financial power of attorney is an immediate power of attorney, meaning that you're giving someone immediate power to act rather than a springing power of attorney that springs into place in the event you're diagnosed to be incompetent. The immediate power of attorney is typically a preferable instrument in that it allows the person access to your financial affairs to pay bills without bearing the time and expense of proving your illness in order to pay bills and access matters. The financial power of attorney is a great document because it obviates the need to go to probate court to have a guardian appointed for you to handle your financial affairs in the event you're unable to handle them. And the guardianship process handled by the probate court in Rhode Island is a public process, and it can tend to be intrusive and costly. So typically a financial power of attorney that is put in place and signed by you is preferential to the guardianship process. Another type of power of attorney that's very important in Rhode Island is a Rhode Island statutory health care power of attorney. And that power of attorney has three components. The first component being that you are appointing someone, a spouse or a loved one, to handle emergency medical decisions on your behalf. Also, if you are incapacitated or don't have the capacity due to illness or medication to handle your own medical affairs. Another component of the medical power of attorney is called the living will. That subcomponent of the medical power of attorney allows someone to terminate life support, i.e. artificial hydration and nutrition, in the event that death is imminent, there is no hope of recovery, and the withdrawal of artificial hydration and nutrition would only prolong the dying process. So another pretty important part of your medical power of attorney that, as we've seen in the Shivo case many years ago, allows someone to terminate your life support, and you're delineating exactly who makes that choice. The third component of your healthcare proxy, your power of attorney, is a HIPAA release. A HIPAA release is a medical release that allows your medical agent the clear authority to access your medical records in order to make a medical decision on your behalf. The next component to the standard estate plan is typically what's known as a will or a revocable trust. And both documents are basically a set of instructions whereby you determine who are the beneficiaries of your estate in the event of your passing and who is handling the administration of your estate. With a will, it's called the executor. With a trust, it's called a trustee. So in that circumstance, you are putting the power into another's hands during incapacity or death so that they can handle the affairs or administration of your estate in the event of your death or passing. The beauty of using a revocable trust instead of a will is that a revocable trust is a private agreement, much like a mini corporation, whereby you delineate who the beneficiaries of your estate are. And a typical trust, if you line up your assets properly along with the trust, does not need to be probated, which means once again that you're avoiding the time and expense of the administration of your estate and not publicly filing anything that folks can look at. So in many instances, the revocable trust can be a preferable instrument to the will in the event that there's some complexity to your family situation, your personal situation, or you really are interested in privacy. And the alternative, a will is also a good option in Rhode Island, particularly because our 39 cities and towns all have their own independent probate court system, and typically in non-COVID times we can get in and out of probate court pretty quickly for administrative purposes. One other component that we layer typically on top of the revocable trust is in a marital couple situation, and that is a revocable trust with Rhode Island state estate tax provisions. Rhode Island is one of those 13 states and jurisdictions, much like Massachusetts, that adheres to an independent state estate tax system. Estate tax is the tax on the transfer of assets not between you and your spouse, but to all other beneficiaries, including children. And for estate tax purposes, all assets inclusive of IRAs, 401ks, and life insurance are includable for the calculation of whether or not you've surpassed Rhode Island's estate tax exemption of $1.5 million. To the extent that your estate exceeds the $1.5 million level, your estate is thereafter subject, upon the death of you and your spouse, to an approximate 9 or 10% tax, which is payable to the Rhode Island Division of Taxation upon your death. With the appropriate planning for a marital couple, if husband and wife each have a revocable trust, husband and wife can each take full advantage of a $1.5 million state estate tax exemption, such that a net $3 million estate can be passed to the next generation free of state estate tax. Certainly that state estate tax exemption is not available for duplication to a non-married couple, but a married couple can obtain significant benefits in passing up to $3 million free of any Rhode Island estate tax. Similarly, in the Commonwealth of Massachusetts, the state estate tax exemption is only $1 million, and so the use of the revocable trust to maximize your state estate tax credits is very important. At this time, I'll sign off, and I'll be making my email and phone available to anyone who might have questions or concerns about the estate planning process. Normally, the estate planning process starts by having a client fill out the questionnaire as to their assets, and that can help us align ownership and beneficiary designation of assets along with the estate planning documents so that there are no unintended consequences. Thanks so much for having me, and I wish you all the best of luck with whatever you're dealing with.